The Honorable Court of Tennessee is now in session.
Good morning and welcome to the continuation of the March 31st session for the Court of Criminal Appeals at Knoxville. Let me introduce the panel to you that'll be hearing this case. To my left is Judge John Everett Williams from Carroll County. To my right is Judge Robert Holloway from Murray County, and I'm Robert Montgomery from Sullivan County. As both of you all know, each side will have 20 minutes for oral argument. If you're the appellant and wish to reserve time for rebuttal, please let me know at the beginning of your argument. Now, Madam Clerk, would you call the next case, please?
State of Tennessee versus Stephen Maurice Mobley.
Okay. All right, Mr. Ridley, you ready to proceed?
Yes, Your Honor.
Do you have do you wish to reserve any time for rebuttal?
Yes, Your Honor. If I could have 3 minutes for rebuttal.
All right, you may proceed.
Okay. Good morning, Your Honors. My name is Todd Ridley, and I'm here today on behalf of Stephen Mobley, the appellant. This is a case arising out of Hamilton County, and I'd like to talk today about 4 issues that are kind of two big issues with little sub-issues in between them. But I'd like to start today with a quick discussion of the 2 issues related to the composition of the jury and the procedure through which the trial court handled the issues that arose about the jury. I guess I'll begin with the Batson issue. So this is all detailed in the brief, but the Batson issue is fairly straightforward. At the outset of jury selection, a Batson issue was raised about the striking of one particular juror who was African American. The error in this case is that the trial court failed more or less entirely to conduct the procedure that Batson required. Essentially what the trial court said was, well, there isn't a pattern yet, therefore there's no Batson issue that can be raised at this stage. So what the trial court was saying was that the first strike of a member of the suspect class is free and the Batson doesn't apply. That's just inaccurate. Batson can apply even if only one juror has been struck. So what the trial court did was it might have ultimately been right had it done the analysis, but it didn't do the analysis. And that's where the error is. So the failure to do the analysis requires that this case be sent back. And Batson is a unique animal in that it doesn't necessarily mean sent back for a new trial. It means usually being sent back for a new Batson hearing. So if that's the error that the court finds, that's the likely remedy. But because there are other errors that I'm going to discuss, the remedy is going to need to be a new trial. But to begin with, there needs to, at a minimum, be a new Batson hearing because of the trial court's failure to comply with the Batson procedure. But that brings me to the second issue related to the jury, which is perhaps a little bit more important because it requires more than just a new Batson hearing. It requires an entirely new trial. That's because the second issue involving this jury led to Mr. Mobley's right to a fair trial being violated. So after trial, it became apparent to the defense and really to everyone that one of the jurors had prior knowledge of Mr. Mobley. And to address this, Mr. Mobley included in his motion for new trial a claim about this particular juror and included with it an affidavit from a witness who indicated that that juror had a few years earlier stated that she knew Mr. Mobley and had an opinion of him. Now, during voir dire in this case, there was a general question about, does anybody on this panel know Mr. Mobley? And nobody answered in the affirmative. That is a problem. The bigger problem, or a problem that needed to be addressed by the trial court. Now, the big problem in this case is that at the motion for new trial hearing, the trial court didn't really allow this to be fully adjudicated. That juror was never asked to testify. And the only thing that we really had was we had the affidavit of this witness who could identify the prior statements by the juror. And then she testified at the motion for new trial hearing. So that was enough to require the trial court to do more than simply dismiss the claim as being unimportant. And for that reason, this case needs a new trial. What we have right now is essentially unrebutted testimony from a witness who can say that one of the jurors who decided that Mr. Mobley was guilty of these crimes not only knew Mr. Mobley prior to hearing the trial, had an opinion of him, and that opinion was not necessarily positive. So that, for that reason, a new trial is required. Those are the two.
Anytime we get an affidavit from a juror that doesn't establish anything other than they talked to him years ago and has nothing related to this trial, that they knew him and had an opinion of him at that time, we need to withdraw all guilty, or we need to throw out all verdicts and have new trials.
I don't think you necessarily need to throw out all verdicts, but it needs to be addressed in more detail than it was in this case. So,
And you put the burden on the trial court. Why has the trial court got a burden in this?
well, the trial court has a burden to allow more to be done than what was done in this case. So,
The law protects jurors
yes,
in this matter. And the judge is just following the law. So why is the judge required? Why are you putting that onus on him? The onus is on the defendant to prove this by clear and convincing evidence. Is that correct?
it is correct that that is the onus. And the important thing, though, is that the defendant did this. When the defendant raised the issue and put on proof that this juror had prior knowledge of the defendant and had an opinion of him, that was enough to trigger the trial court to do more. The trial court said,
The trial court just can say, don't believe him. Go on, can't he? Or
Well,
can't she?
I don't think that's sufficient when it's unrebutted proof. So what the trial court did in this case was not really say, I don't believe this witness. The trial court said,
Proof that is unrebutted can be just an absolute lie and totally inconsequential and irrelevant to anything presented to the court. And if the court finds that, it's over, right?
oh, okay, I suppose if the trial judge had said, I flat out don't believe you, there's no way this is true, I think that's certainly something a trial court can do. If trial court finds that, it probably is over. That's not exactly what the trial court did in this case, though. What the trial court did was say, I'm a little bit conflicted. I've got this testimony, but this testimony went beyond what was in the affidavit, and therefore I'm a little bit suspicious of it. And the end. That's the end of the inquiry. The inquiry needs to be more substantive than that. So I think that's the problem where we run into, is that the trial judge basically cut off the inquiry when we only have some evidence that, no, this juror had this knowledge, and the trial court is not exactly saying it didn't happen. It's just ending the inquiry. And that's, I think, the problem with the procedure that the trial court employed.
Well, it ended the inquiry about calling the other juror.
Right. That's exactly.
He didn't end the proof in any shape, form, or fashion.
Well, I mean, I think the only thing that could be done at that point was, I think the trial court needed to hear from this juror, because that would clear up the problem. I mean, there is no problem at all. If the juror comes in and says, no, that didn't happen, or I don't remember that, or I didn't remember him, or that conversation that took place, then there's no problem. The problem is, the only thing we have right now is a witness coming in and saying, this juror had this information. And the problem again that I come back to is the juror at the beginning of trial said, or implicitly said, I've never met this man. I don't know who he is. I can therefore be a fair juror. What we have now is proof that that might not have been so. For this to be fully adjudicated and fairly adjudicated, there needs to be something from the trial court to say, we need to get this juror in here and ask some questions. Now, maybe the juror answers those questions to the trial judge's satisfaction, and that ends the inquiry. The juror says, nope, that didn't happen. I never met him. I didn't know anything about him. Or if I did, it was fleeting and I didn't really remember it. And it certainly didn't affect my verdict, or certainly didn't affect the way I saw the case.
You don't think, Counselor, that wouldn't have a chilling effect upon people serving on jurors if they were going to be called after every trial and questioned about who they knew, when they knew them, if they'd ever seen them at the Walmart, if they'd ever been at a grocery store with them, if they'd ever been at a party with them?
I don't think it would have a chilling effect at all, because right now the law is you're supposed to say, when asked during voir dire, if you've met the defendant, and if proof comes out later that that was inaccurate, that needs to be adjudicated. And
what if it, I mean, you don't remember it, so it's a truthful statement?
I'm not sure I understand that part.
The juror told the truth. The juror does not remember ever meeting you or a witness anywhere. So why do we subject them to that cross-examination and put them on a witness stand every time? We protect jurors and their service.
I fully agree that we.
And the judge had some question about this. The witness that the defendant called in this case, he questioned that witness's credibility or something. I think he was concerned about that.
I agree that the judge expressed some concerns. I don't agree that the judge came right out and said, I don't believe this witness. What the judge did, in my mind, was say, we've got this affidavit. It makes certain allegations. The allegations that witness made at the motion for a new trial hearing went beyond what was in the affidavit. This is common when we have live testimony versus affidavits. Almost always when somebody starts talking rather than writing it down for an affidavit, they almost always go into more detail. That's why we have them testify in person rather than doing it on paper. What the judge did was say, well, because her motion for new trial testimony went beyond what was in the affidavit, I'm going to conclude that, well, maybe it's not as reliable. But that's where there becomes an issue, because in and of itself, going beyond what is in the affidavit doesn't say anything about its reliability. It just says that she, like pretty much every witness that we've ever had, goes into more detail in person than they do on paper. And that's all that happened. So I guess I disagree that the judge just flat out rejected the testimony. The judge was basically, and I also would say the state at the motion for new trial hearing didn't come right out and say, you're obviously lying. They said, well, you're going into more detail than you went into earlier, and we have some questions and concerns. And I would just say, once that much happened, that there were questions and concerns, then all that needed to happen was, again, this is under seal. It can be a closed courtroom. The judge just calls the jury in and says, we have some questions about your service. And maybe those questions are answered satisfactorily. And it's likely that in most cases, they would be answered satisfactorily. And that's enough to cure any allegation of a problem. But what the judge did here was in the inquiry. And that's where we have a problem, because we have this affidavit and testimony that is critical. It says there is a person on the jury who had knowledge of the defendant and didn't disclose it. And that is enough to trigger the trial judge to do more than say, well, I don't want to hear anymore. I'm just going to deny. So,
Mr. Ridley,
yes,
so you have an affidavit. Is that the one where they said he was crazy or something like that? Is that what the affidavit said?
I think it was the testimony that went beyond the affidavit. So the affidavit says, I had a conversation with the juror, and she mentioned that she knew him. And then I think it's at the hearing that she says, during that conversation, she commented that Mr. Mobley was crazy.
So this is the niece of the defendant and the mother of one of the defendant's children that testified or gave the information?
The person who testified is the niece.
Okay.
About the crazy part, the mother of one of his children testified that she had seen the juror at a party, and so indicated that they knew each other.
And the juror Bell said she didn't remember the guy or something like that by affidavit, correct?
In the affidavit, but was not asked to testify at the hearing.
Thanks.
Oh, okay, so sorry about that. So I think that pretty much addresses the issue of, or at least factually, and what our legal concerns are. And again, this is one of those things that I would not be concerned about it coming up that often, just because most of the time this doesn't happen. Most of the time when the jurors are asked questions, they answer them, and it just doesn't come up again. But when it does, it's incumbent upon the trial court to do a little bit more than what the trial court did in this case. And for that reason, this potential problem with the jury composition in this case requires that this case be remanded for a new trial. But with those two kind of big jury issues, I'll turn to my two evidentiary issues and then wrap it up. The evidentiary issues are fairly straightforward. The first is one of more or less simple relevance. At trial, the state presented evidence that Mr. Mobley was on the top 10 most wanted list of the TBI. There was an objection to this, and the objection is the obvious one. The objection is it is absolutely irrelevant that Mr. Mobley was placed on the TBI's top 10 most wanted list. The only purpose of eliciting that testimony in this case was to paint Mr. Mobley as a violent person who was a danger to the community. At trial, and I suppose now on appeal, the state has justified this evidence by saying, oh, it's relevant to show consciousness of guilt. The TBI most wanted list does not show consciousness of anybody other than the TBI agents who prepared it. It might be relevant had there been some evidence that Mr. Mobley was aware he was on the most wanted list and continued to flee, but no such evidence was presented. The only evidence.
Did the judge charge flight?
Yes.
And is it not circumstantial evidence perhaps of flight?
Well, I don't think it is, because again, for it to be relevant towards the issue of flight, there would have to be some evidence that Mr. Mobley knew he was on the most wanted list. Or there had to be some evidence that it was well publicized in the area, so publicized, in fact, that he must have known about it. That's not what happened. I mean, this is one of those things where I was thinking about it this morning. I've been doing criminal justice for a long time now, and in general, I have no idea who is on the TBI's most wanted list. So just the mere fact that he's on it is not going to say anything about Mr. Mobley's consciousness or whether he is fleeing from it. You'd have to put on some proof that he knew about it, or that there was such pervasive media coverage of it that he must have known about it.
So if you had a police officer or detective that said, you know, we searched for Mr. Mobley, we could not find him, he wasn't at home, his car was gone, you're going to say that wouldn't be relevant because Mr. Mobley didn't know that they were doing that?
I think I would say that for those particular facts, I think those would be far less prejudicial than being on the top 10 most wanted list. So if an officer said, well, I went to his house and he wasn't there, I agree there's probably a relevance objection, and who knows, that could go either way. But I don't think that's particularly prejudicial. Saying, well, the detectives went to his house, they called his house and they couldn't find him. Maybe not, that goes to flight, but it's certainly not prejudicial. But saying somebody's on the top 10 most wanted list in the state, on the other hand, is extremely prejudicial. In fact, the only reason to do it is to show that he is a threat to the community. They don't put ordinary run-of-the-mill suspects on that list. They only do it when they, I assume at least, only do it when they think it's a threat to the community. And that's why they wanted that information in front of the jury. So I take your point that sometimes, you know, officers' efforts to track down a defendant are going to be relevant, maybe not, to show flight. But there is a difference, and a pretty substantial one, between those ordinary investigative techniques and the top 10 most wanted list, which is what happened.
Mr. Ridley, You have about 2 minutes remaining.
Oh, okay. Thank you, Your Honor. I'll wrap this one up really quick. The last evidentiary issue
Well,
that.
no, I mean 2 minutes, like you're into your rebuttal time.
Oh, in that case, I'll rely on the briefs for the hearsay issue and save the remainder of my time for rebuttal. Thank you.
All right, General.
Your Honors, and may it please the court, Cody Brandon for the state of Tennessee. We respectfully request that this court affirm the judgments of the trial court. Unless Your Honors have questions about other issues, I'll confine my argument to the issues addressed by opposing counsel and keep the same order as well. So first, Your Honors, the trial court's denial of defendant's Batson challenge does not require a new trial and was not clearly erroneous. Batson sets up a 3-step process for addressing objections to the peremptory strike of the juror. First, a defendant is required to make out a prima facie case of purposeful discrimination. That prima facie case has to show a discriminatory purpose in light of all of the relevant circumstances. If the defendant clears that hurdle, then the trial court is required to elicit a race-neutral explanation from the state and then evaluate that explanation in the totality of the evidence before the trial court and determine whether a juror has been struck purposefully with a discriminatory intent. Here, the trial court's determination that defendant did not make out a prima facie case of discrimination was not clearly erroneous. In light of the relevant circumstances, the trial court had evidence that, as it mentioned, that there was no pattern of discriminatory action and that there was no evidence of disinterest by the prosecutor in anything but race. Indeed, the prosecutor and defense had repeatedly questioned this juror about her ability to transport herself to the hotel where the jury was going to be sequestered. And she said that she relied on her son for transportation and her son had just left the country. So there were questions about her ability to be transported. There were also questions about her ability to serve. The juror repeatedly expressed hesitation about service on the jury and about sitting in judgment of others. The juror had previously acquitted another defendant in a trial that she served on previously. And the juror was present at an event that defense counsel also attended a few months, I believe, before the trial. So in light of those relevant circumstances, the trial court's decision not to require a race-neutral explanation from the state was not clearly erroneous.
Was the trial judge correct in his initial assessment that you've got to have struck more than one black juror before this becomes a pattern?
That, as a matter of law, that's not correct, Your Honor. State versus Ellison says that one strike can demonstrate a discriminatory purpose, but the trial court.
Isn't it true the whole rationale behind Batson has been that the Supreme Court of the United States has determined that throughout the history of our jurisprudence, we have been discriminatory against black jurors, and therefore, in an attempt to rectify that situation, we look at striking of black jurors with disfavor?
That's correct, Your Honor. There is certainly a higher standard there for Batson, but it is still the defendant's burden to make out that prima facie case first. And the trial court's reasoning was not extensive here. It did make a remark about there not being a pattern. But again, the prima facie case must be taken in light of all of the relevant circumstances. And taken here, the trial court's comment can be understood as saying that there's not enough evidence here of a prima facie case, that given this juror's concerns with transportation, her hesitation to sit in judgment of others, her previous acquittal of a defendant in another trial, her contact with defense counsel at a bench prior to the trial, that in light of those circumstances, there was not going to be evidence of purposeful discrimination unless there was a pattern of discriminatory strikes in this case. So that decision was not clearly erroneous. The trial court, again, as the Supreme Court emphasized in Batson, these situations are treated sensitively and ought to be handled with care, but great deference is given to the trial court, who's able to assess the credibility and demeanor of the prosecutor, is present for all of jury selection and knows the questions that are asked, and is able to assess the responses of the prospective juror and any demeanor or hesitation there in the juror's responses. So the trial court's decision not to require a race neutral explanation should be accorded great deference and not be overturned by this court. Secondly,
Well, I would probably phrase it just a little bit different, General. I think it looks like to me he didn't require one; he already had one.
Well, that's certainly correct, Your Honor. That there are quite a few race neutral explanations, and that again is why there's that prima facie burden on the defendant, is that that it has to be taken in light of all the relevant circumstances. And here, of course, there are plenty of race neutral explanations that the trial court did not need to probe into the prosecutor's intent for that strike. Secondly, Your Honors, the trial court did not err in denying defendants' post-trial challenge to the inclusion of a juror that had a distant relationship to the defendant on the jury. The trial court simply found that defendant's witness that testified to the relationship and the alleged opinion of the juror about the defendant was unreliable, and that in light of the juror's responses to questions during jury selection and the affidavit submitted, that he found that the juror simply did not have any knowledge of the defendant at the time of the trial. As Your Honor, Judge Williams pointed out, it's perfectly possible that even if the trial court did credit defendant's witness and did believe that a conversation happened years before trial in which this juror made a comment about the defendant, that she could have truthfully answered that question and forgotten about that conversation before trial and had no knowledge of defendant that was brought into the deliberation room. So even without the credibility and unreliability determinations by the trial court, the evidence put on by a defendant in the affidavit and at the hearing of the motion for new trial didn't conclusively establish, if all taken as true, that the juror was lying during jury selection. And again, the trial court found that the witness's testimony and affidavit were unreliable. It credited the juror's responses during jury selection and in the affidavit. And again, this is a situation where the trial court has the ability to judge the demeanor and credibility of both the juror during jury selection and the witnesses before the court, and is operating in an especially sensitive area of questioning jurors after a trial. We have evidentiary rules in place, and this court has been hesitant to probe into the thought processes or question jurors after trial in order to, again, as Your Honors pointed out, protect the deliberative process of the jury and to avoid harassing jurors after the fact. And so the trial court engaged in a very reasonable investigation here, allowing some evidence by affidavit and listening to this witness before it determined that the investigation needn't go any further to determine the relationship here. But even if, even in the case that the investigation should have continued, the distant relationship, the juror was defendant's son's mother's sister's husband's niece, I believe is how it's described in the record. That distant casual relationship, which at most, according to one witness, resulted in some attendance at parties, is not enough to necessitate a new trial. So this court should affirm the trial court's holding that juror's participation in deliberations does not require a new trial. Lastly, Your Honors, turning to the admission of defendant's inclusion on the wanted list. The inclusion of defendant on the wanted list was not admitted as a standalone fact. It was not admitted as just defendant was on the wanted list. This was part of the state's telling of its investigative story and about defendants' efforts to evade arrest. So the state admitted evidence that the police sought out defendant at a motel and couldn't find him. Later, because of their failed attempts to locate him and track him down, contacted the TBI about placing the defendant on the wanted list, and then explained to the jury what the effects of placing someone on the wanted list was, that his information is going to be sent to law enforcement and news agencies across the state, that results in news bulletins and police across the state looking for him. And again, as your honors noted, that is circumstantial evidence of defendants' attempts to evade capture and to continue to flee. And then more circumstantial evidence comes in that shortly after he's placed on the wanted list and the statewide search for the defendant begins, he makes a Facebook video responding to accusations that he's involved in this crime and explaining his motives in going on rampages, that he's motivated by disrespect and not by sexual frustration. So all of that was relevant and probative to defendants' consciousness of guilt and flight from the scene. It was information that was highly probative to the jury, and it was not unfairly prejudicial. This is I think counsel called it ordinary run-of-the-mill suspects are not normally placed on the wanted list, and the jury already knew that defendant was not an ordinary run-of-the-mill suspect. He'd been accused of a double murder and an attempted murder, that he shot 3 people in cold blood while they were seated on couches and left the house, left the 3rd victim to die, and fled from police. That was information the jury already had from the indictment and the other proof. So the fact that defendant was a violent suspect that was fleeing police was not new to the jury. The admission of his inclusion on the wanted list was part of that investigative story and evidence of the great lengths that defendant went to evade capture until the pressure mounted and he decided to surrender himself after explaining to the community that he was motivated to rampage because of disrespect. For those reasons and for the other reasons relied on in the state's brief, if your honors have no further questions, we respectfully request that this court affirm the judgments of the trial court.
Okay. All right, thank you. Mr. Ridley?
I thank you, Your Honor. I'll be brief. I guess just to go from right where we just ended, the top 10 lists, again, showed nothing about Mr. Mobley's state of mind. It again showed something about the TBI's state of mind and about the investigative state of mind. But what we know from this case is that Mr. Mobley voluntarily surrendered himself to the police shortly after the investigation began. We have no evidence that his placement on the top 10 list had anything to do with that. All we know is that the state wanted this information in so that they could paint Mr. Mobley as what the general is now describing it as. But that's what the jury was there to decide. That was not yet a fact. And so the use of the TBI list to capture that was unnecessary and prejudicial. I'll go now to the Batson issue. So the general made some articulate reasons of why this juror could have been excused. Those are perfectly good reasons why a juror might be excused, but that is not what the trial judge did. Had the trial judge said all of those things, or had the state said all of those things, we wouldn't be here on this issue. The problem is not that there's not potentially out there some way that somebody might excuse this juror. The problem is that the trial judge didn't do what he was expected to do under Batson. That's why we're here. It's a failure of procedure. And so for the state to now come up with reasons why excusing this juror might have been appropriate misses the point. Surely, certainly, a year after the fact, anybody looking at the transcript can come up with a reason for dismissing the juror, but that's not what the trial judge was expected to do. The trial judge was expected, upon hearing the objection, to follow the law and follow the procedure that's laid out in Batson. Then turning to the final thing with the last juror, counsel mentioned something about, well, the trial court's in the best position to evaluate the demeanor of the witness. And what he meant there was, I think, the demeanor of the juror in question. Well, if the juror in question never testifies, is never asked to answer any questions under oath, the trial judge can't make that call. can't do that, can't evaluate credibility and demeanor to determine what's true and what's not. We just have these affidavits. And that's why the trial judge's methodology and procedure failed. Because we didn't have that critical function of fact finding that the trial judge is expected to do, we just don't know a lot of these things that we need to know to determine if this was a fair process. And since I believe my time is probably now up, we just ask that the court reverse, thank you, Your Honor, and remand for new trial. Thank you.
Okay, all right. Thank you to the attorneys for your participating in an oral argument using this format. Our court greatly appreciates your working with us to have your cases heard virtually. Now, we'll be in recess then until 1 o'clock p.m.
This Honorable Court of Tennessee is now in recess.